Welcome to this UCL lunch hour lecture on changing state behavior, the role of international and human rights courts, marking Human Rights Day. My name is Dr. Danaya Zaria, and I'm Associate Professor of Public International Law at the Faculty of Laws of University College London, UCL. And it is my honor and pleasure to introduce today's speaker, Professor Veronika Fikfak. Veronika Fikfak is a professor of human rights and international law at UCL, the School of Public Policy, and a co-director of the UCL Institute for Human Rights. Veronika leads a team of 6 researchers on the ERC project Human Rights Nudge, which looks at how states respond to judgments of the European Court of Human Rights. From 2025, she will be in charge of her next ERC project on access to international human rights justice and a UCL Grand Challenges project on barriers to international climate justice for children. Veronika is a Secretary General of the European Society of International Law and a managing editor of the American Journal of International Law Unbound. She also serves as a judge ad hoc of the European Court of Human Rights. Now, before we begin, I wanted to let you know that we will have some time at the end of the lecture for questions. And you can submit these at any point during the talk by going to slide.do, enter in your internet browser and entering the event code, which is #court. I will now hand over to Veronika for her talk. Thank you, Veronika.
Thank you very much, and thank you everyone for joining us on this Human Rights Day where we celebrate human rights. So I wanted to talk today about a recent development in international law and human rights law, and that is that increasingly more and more disputes are entrusted to human rights, regional human rights and international courts. And we are seeing conflicts like the Israel-Gaza conflict, the invasion of Ukraine by Russia, all make it to international tribunals and regional courts. We're also seeing in the area of climate change, for example, this week in front of the International Court of Justice, states are appearing this week and the previous week to explain what they think their obligations are under international law. So a number of institutions at international level are engaged in determining what the law is and really engaged in these very new conflicts. And so the question really is, for me and for a lot of us international scholars, what role do courts play in this context? Can their decisions really lead to or stimulate a change in behavior on the part of states? And how much can we count on these institutions to actually lead to a change in behavior? So in this talk, I'd like to make 4 points. The first one is I want to address why more and more cases are being litigated before international human rights courts. Secondly, I'd like to introduce these courts and explain what disputes they specialize in. Thirdly, I'd like to outline what type of enforcement issues these courts face and how states decide whether they want to comply with judgments of international, regional, and human rights courts or not. And finally, I'll come to the questions, which is really the title of this talk, and that is, what is the role that the courts can play in changing state behavior? So here you see on the slide really a new phenomenon, right? And that's really my first point, which is that we're seeing more and more live conflicts come to international courts and tribunals and to regional courts and tribunals. And you see on the slide both the discussion or the intervention in the South Africa versus Israel, the climate change cases, the Klima Seniorinen case before the European Court of Human Rights, and the Ukraine versus Russia cases coming both before the European Court of Human Rights and the International Court of Justice. And the question is why? Why are these cases coming to these courts? And there are multiple factors really that are influencing this situation. The first one that I'd very much like to underline, and that is that we're living in a world where international community and states are essentially failing to come together to agree to new international norms and treaties and agreements. You will have seen a few weeks ago in Azerbaijan, the end of COP, so in the climate context, really a convention bringing together states to agree to new climate obligations. And that was really, in some sense, a failed meeting, a failed summit, where that kind of agreement wasn't really reached, or where no important progress was made. And this is not really just a phenomenon that is present in climate change. We're seeing it in many, many areas in international law today. So in some sense, we're living in very different times than we were living after the two world wars in 1945 and 1950s, when states were very keen to legislate that the atrocities that had occurred after the two world wars should never happen again. And that was really the golden age of international law production, the agreements, the Universal Declaration of Human Rights, European Convention on Human Rights, but also the UN Charter and a number of different really agreements that led and conventions that led to us having the international law that we have today. Today, in contrast, states are much more reluctant to enter into these new agreements and accept international obligations. So that's really the first issue. The second issue is the question of really respect for international law. So when violations of international law used to occur, and here we can think about the invasion of Ukraine by Russia, we can think about the Israel and Gaza situation, these situations used to be debated and resolved by the Security Council. So United Nations, a political body where you've got 15 members sitting together. And what the Security Council would do in these kind of situations is it would issue sanctions, it would trigger a response or ask for a response from the international community. And what that meant is issuing of economic sanctions, the breaking of diplomatic relationships. It would require withdrawal of troops. It would condemn actions as unlawful. It would call for a ceasefire and encourage states not to recognize certain state as for example, a change in boundaries as we're seeing in Ukraine today. And the problem is that the way that the Security Council was set up in the 1950s is that it allows for specific countries to have veto power. And that veto power means that countries, individual countries, can block the acceptance or adoption of any resolution. And we're seeing that today. So in relation to, for example, Palestine, the US vetoed the admission of Palestine as a new member. Same in relation to multiple resolutions relating to Israel-Hamas war. In relation to Russia and the Russian invasion of Ukraine, Russia and China vetoed a resolution requiring the withdrawal of Russian troops from Ukraine. They vetoed a resolution requiring the reversal of any actions and decisions, and a resolution that called on Russia to refrain from any further unlawful use of force. So if once these conflicts were resolved politically, now the political route or search for political solutions through the Security Council is very much blocked. And so we find ourselves in a world where the United Nations Security Council, or the institution that we have, is not able to intervene appropriately. We find ourselves in a world where states do not have the impetus, do not have the wish to reach new agreements and agree to new obligations. And we find ourselves in a situation where states are more and more entrenched in the positions they take, both in relation to individuals and in relation to other states. And so what ends up happening is that those who are affected by these situations, individuals on the ground or other states, have no other choice but to turn to international and human rights courts to make these cases and to ask the courts for protection of their rights. And so as a consequence, we have seen in these 2-3 years of very public disputes make it both to The Hague, as you see on the picture there, and to Strasbourg, the European Court of Human Rights. So that then really leads me to the second question, which is who are these courts and what do they do? And I'll talk about two. So the International Court of Justice, which is in the news today because of the climate change cases, is a court that is located in The Hague, and it is responsible for adjudicating disputes between states. In recent years, this court has been really seized by different countries, both to adjudicate cases brought by South Africa against Israel, in relation to allegations of genocide committed by Israel, and then also in cases like Ukraine versus Russia, also on the question of the invasion of Ukraine. And this week, as I said, it's really hearing cases. What are the obligations of states in relation to climate change? The court has, beyond these examples, adjudicated many other cases, setting boundaries between states and other things. It is what we call the World Court. So it is the main court of the United Nations and allows states to sue each other as long as they have consented to its jurisdiction. And once it hears the case, it will render a binding judgment. It can render both provisional measures, but in the end, it renders a binding judgment that creates obligations on states to respect those decisions. And it has about 15 judges sitting on it. So that's the ICJ. We also have the European Court of Human Rights, which has jurisdiction to hear claims brought by individuals against 46 countries of the Council of Europe. It used to be 47 countries, but when Russia invaded Ukraine in 2022, it was expelled from the Council of Europe. And the European Court of Human Rights hears claims brought by individuals that relate to human rights violations. So, for example, these include very big rights like freedom of speech, right to privacy, right to be free from torture, and right to life. There are 46 judges, one from each country, that sit on this court and that again issue binding decisions. But slightly differently from the ICJ, there is a specific body that is there to really supervise whether or not these judgments have been implemented and what has been done. And one of the most important or interesting decisions that has come out in the last year is the Klimasenjorinen case, which was a case against Switzerland in relation to climate change. And that was a case brought by a group of elderly women who argued that they suffer earlier death and serious health consequences as a result of climate change, and that Switzerland has failed to take appropriate preventative action. In that case, the court agreed with Klimasenjorinen, the NGO or the group, and argued that Switzerland definitely had failed to protect its citizens from climate change, and that it had to do something, that it had to reassess its position and adopt new policies and new goals to fight climate change. Now, in addition to these two courts, there are many other courts in the international landscape that are responsible for looking at these matters or different cases. So we've got International Tribunal on the Law of the Sea, which has already rendered a decision on climate change. We also have other regional courts like the Inter-American Court of Human Rights, like the African Court of Human Rights, and these also deal with the regional aspects of human rights. In addition to that, we have the International Criminal Court that has also been in the news, which is responsible for persecuting individuals who have committed crimes against humanity or other crimes under the Rome Statute. So that's in some sense the landscape, and it's a landscape that shows where states and individuals can turn to have their disputes resolved. And where states and individuals turn to clarify what the international legal standards are and what human rights should be respected. Now, in the majority of these cases, the courts will issue binding judgments or interim decisions. And the question really is, what do these say, right? So what do these say? So what does the court expect of countries to do in response to a judgment, in response to an interim measure? And I've put here really our three cases, the ones that I included in the abstract and that I'm talking about. And I'll just outline briefly what the court said in each one of them. So in the Ukraine versus Russia case, when Ukraine sued Russia before the European Court of Human Rights for invading its territory, The court issued interim measures, so that's a provisional order in between proceedings before the final decision is made, and it required Russia to refrain from military attacks against civilians and against civilian objects. It required Russia to allow safe evacuation of civilians. It required Russia to provide passage of humanitarian aid and humanitarian workers. That's one example. Similar provisional measures were rendered by the ICJ in relation to Gaza, so in the case of South Africa versus Israel. And there, what the court required of Israel to do is to act in a way that it would prevent genocide and desist from killing, injuring, destroying life, desist from incitement or encouragement to genocide, that it had to enable the provision of humanitarian assistance. And then in a second interim measure, what the ICJ asked Israel to do or ordered is that it halts the Rafah offensive. And then finally, in the Klima Seniorinnen case, so the climate change case, where elderly women were concerned about climate change and the impact on their quality of life, there we have the European Court of Human Rights essentially coming to a conclusion, coming to a final judgment, and requiring the state to devise, develop, and implement new legislation and to adopt measures, including through a carbon budget and national greenhouse gas emissions limitations. So Switzerland has to come back and adopt new legislation. It has to come back and adopt new policies that would limit these emissions and that would reduce the targets that it has thus far had. These are the types of decisions that these courts render, and these are the types of obligations and requirements that these courts impose on states. Now, the problem is that international courts and tribunals, once they've made a decision, they really face a problem of enforcement. And that means that there is no mechanism that would ensure that states, once a judgment has been rendered, respect these judgments. So for example, in domestic law, if you have a judgment of a domestic court, what you would do is you would go to the police, or in the worst case, the state would call the army in to ensure that judicial decisions are being respected. So we have some sort of an enforcement mechanism that ensures that judgments of a court, of a domestic court, are respected. We have nothing like that in international law. And so in international law, the enforcement of human rights is very much dependent on voluntary actions of states. That means that states have to decide themselves whether they will comply with the decision or not. What it means is that some decisions are respected and others are ignored. So if we come back to our three cases, we're looking at Ukraine versus Russia, where Russia is required to stop the attacks in Ukraine. It is required to stop the killing of civilians. Thus far, Russia has ignored this interim measure issued by the European Court of Human Rights. And even more broadly, when we look at Russia's behavior, there are more than 1,000 cases rendered by the European Court of Human Rights that Russia has refused to essentially implement. And at the moment, Russia owes 2.8 billion euros in compensations to different human rights victims, which it has consistently refused to pay. So that's one example. The other example is South Africa versus Israel, where there was an obligation to cease hostilities in the Rafah region. That has not been respected. And then if we turn to Klima Seniorinnen case, when it comes to the issue of climate change, Switzerland has been, after the decision, very vocal that it has no plans to change its legislation in a way that would comply with the Strasbourg decision. Now, I really want to underline that this refusal by states to respect international decisions is not limited to the cases mentioned. For example, when the ICC issued an arrest warrant against Putin, and then he visited Mongolia, who's a member of the Rome Statute, and has an obligation to enforce the arrest warrant, Putin was not arrested. and the country refused to execute the arrest warrant and fulfill its obligations under the Rome Statute. So what these cases show is that the fate of international decisions is very much in the hands of state. So the question then for us is, how do states decide whether they wish to comply with these judgments, and what type of factors might influence their decision to do so? And really, I've put on this slide 4 different things that come into play, that come into the equation, and that affect whether or not a state will end up voluntarily complying with a judgment or not. And I think, firstly, I really want to underline that in the majority of cases, states do comply. So they do respect decisions of international courts and tribunals. And they do this because really they consider that they are members of a specific club. If you think about the United Nations, you think about the Council of Europe or the European Union, states draw certain benefits from being part of these institutions, of these communities, whether that benefits are trade, whether it's getting protection or other things. Those things motivate states to speak about themselves and think about themselves as partners in the international arena. And that's one of the things we're finding in our project Human Rights Nudge, that actually, for example, in the European context, we're looking at 80% on average compliance rate with decisions of the European Court of Human Rights. So it's quite high. In this context of being members of a club, what states will do when they look at a country that is consistently refusing to comply, essentially they tend to isolate or exclude that country from bilateral, multilateral discussions, and that country will find itself in a very difficult, I'll say, position on their own in an organization. That used to be the case very much with Russia, but it is also happening to other countries. So membership of a club is a really important motivation for states to comply with judgments. The second one that I would say is the question of reputation that goes a bit beyond membership. So the reality is that if states fail to comply with these rules that we've written down, international law, human rights, which are essentially rules of the game in international diplomacy, if they fail to do this, this will have important reputational damage for them. So if other states call them out, or if activists call them out, or NGOs, or we see a lot of mobilization of these groups, what happens is that states will be concerned about how this is likely to damage their reputation, and they may actually work preventatively to ensure that such reputational damage doesn't take place. And so we call this naming and shaming. And naming and shaming has been in a number of studies shown to work in relation to specific violations, not all, not, let's say, dictatorships, but in a specific situations, it does work. And it's a tool that international community uses to make sure that states comply. Now, beyond these international reasons and international incentives for when states comply voluntarily, we also have domestic considerations that will affect whether a state will accept a decision of an international or domestic court. And I think the first one that I would underline is the question of capacity, right? Internal capacity. States often will have to think about enforcement or execution of a certain judgment in a way where it will have implications for their resources. So sometimes countries have to totally redesign their domestic legal order. They have to introduce new institutions. That takes time. It also takes a lot of money. And in addition to that, it really takes know-how. So if states don't share good practices between them, if they don't have access to how things should be done, that really affects their capacity to voluntarily comply with the judgment. And multiple international institutions are currently looking at ways to share this know-how and to ensure that states are able to then act on that know-how. The other thing that is, I would say, in the last 5 to 10 years, very prevalent and very important is the influence of domestic politics on international behavior of a state. So whether or not a state complies internationally will depend on what's happening at home. And that is who is in power at home, whether a state has independent courts, and these courts can potentially execute international decisions. It depends on whether there is general domestic support within a country for compliance, and similar reasons. And in some countries, we are really seeing that internal politics can very much override any appetite for compliance at international level. And we're seeing countries like Russia, Hungary, and Poland legislating domestically to prevent its own internal organs from implementing decisions of international character. So these are countries, and it will depend on the cases, it will depend on the area, that are choosing to openly defy international courts and regional courts, and where judgments remain enforced. And so this sort of mapped out the situation of what are the courts we have, what are the judgments they render, but also how do states think about compliance? What do they prioritize when they're taking that into account? And so the question that then sort of we're left with is, in this limited world, a world where states are very much dictating or choosing their behavior, what is the role for the courts? And I'd like to really put forward 3 arguments of why we have international courts, what role they play, and why this is a particularly sensitive, but a particularly important moment for us to engage with these courts. So the first one is that courts are there very much to clarify the international law. So new conflicts and new situations always raise issues about whether and which law is applicable and how. So we are seeing at the moment, for example, in relation to climate change, we are unclear what the obligations are, what states have actually agreed to, what the practice has shown up. So for example, if climate change is endangering people's livelihoods, their homes, their land, their families, are states, by failing to act, violating individuals' obligations to protect their home, their property? And if they're doing this, and that we need to determine what are the precise obligations of states in this respect. So for example, in relation to the impacts that climate change is having, is the obligation only one to take into account climate change when they're legislating, where they're adopting policies, or is the obligation actually to reduce emissions, to meet specific targets, etc.? So is it an obligation of process, of consideration, or is it an obligation of outcome? And so it is the courts really today that are playing a major part in outlining the scope of these duties. And it is the courts that are today telling us what the present or the current state of law is, how far the law has evolved, and where we are today. Now, if states obviously comply with these judgments once the law is clarified voluntarily, this will obviously lead very quickly to change in behavior. And I really want to underline that we've got a number of cases where this has taken place. So for example, just for the UK, the decisions of the European Court of Human Rights have led to several improvements in English legislation. Number one, they have led to, for example, a decision of the European Court of Human Rights finding prohibition of the members of LGBT from serving in the military unlawful. So that was found to be unlawful. That decision led to a change in legislation at home in the UK. And that now means that today members of LGBT communities can serve in the military. Number two, there was a famous case of prisoner voting where the UK prohibited any prisoner from voting through the ECHR decision, which found the violation there. That has now been changed, and a small group of prisoners are able to vote today. In another case, for example, the ECHR held that retaining your fingerprints and DNA samples in a case where you were not found guilty in criminal proceedings was unlawful, and that led to a change in practice. And then more generally, right, in addition to, for example, decriminalizing homosexuality in Northern Ireland, the court has also been responsible for finding phone hacking illegal and for ensuring that employers can no longer read our emails without our consent. So a decision, especially when it's followed by a state who voluntarily complies, very much leads to a change in behavior, a change in law, and a different standard, different human rights standard for everyone involved, especially for individuals and human rights victims. Now, if states refuse to respect the decisions of the court, then the role of the court is slightly different. And this is what leads me to my second point. So I think that when we get these judgments of the court in cases of non-compliance, when states refuse to comply, what happens to the judgments is that they create a focal point around which different actors can mobilize. What does that mean? So if we look at the Klima Signorinen case, that case on climate justice and elderly women really raising the case against Switzerland, that case was raised very much as a result of strategic litigation of NGOs, activists, academics coming together, fighting for a broader move, right? A broader move in international law, human rights law, to really understand what the scope of obligations for states is and how states should, what they need to do to comply with the convention. And that was not only Switzerland, there were other cases against Portugal, etc. But even after the judgment was rendered in that case, NGOs have mobilized and other actors are really now fighting and arguing for enforcement of these judgments by Switzerland. So having a piece of paper, especially when a state is refusing to comply, in some sense completely changes the game, because as an activist, as an NGO, as an academic, as a victim, you're able to say, this is the decision, this is what the obligation was, this is how the state has acted unlawfully, and this is what it needs to do. So having that piece of paper totally puts pressure on states, on politicians, and they need to defend themselves against criticism why they're not taking certain action and why they're failing to do so. And this can be very damaging for states' reputation. For example, I mentioned Russia before and how it's really failing to implement or comply with more than 1,000 judgments of the European Court of Human Rights, and a caseload in which it owes to people 2.8 billion euros in compensation. And that discussion now has led actually other states in the Council of Europe to start discussing whether Russian assets located in different places in Europe should be seized, should be taken hold of to ensure that these human rights victims are paid. So these are discussions that are currently taking place and that would really importantly redesign how we think about international law, and that would bring into international law some sort of forcible enforcement of human rights judgments. So that's the second one. I think a broader role of the court, though, is the third point, and that is that what courts do through their judgments is they create new precedents, what we call precedents. So they create new judgments, they create new law, and in that way, they go much beyond just resolving the specific disputes between an individual in a state or between two states. What they do is, even if they are creating an obligation just for a specific country that is named in the case, they also show where the law is. And for other states who were not involved in the case, what that can do is it can really act as a nudge, as an incentive for them to make a change to their own legislation and to preemptively change behavior so that they are not found in violation in the future. So, for example, in the Klima Signorinen case, the court, when it stated that Switzerland has failed to protect its citizens from climate change, and that it needs to reassess its policies, adopt new legislation, and act towards new climate goals. What other states can do is, in the light of this judgment, look at how their legislation compares to the Swiss legislation, look at whether or not they're ticking the boxes that the court really very much names in the judgment. And so in that sense, even if Switzerland resists in the long term, other states can preempt violations and can, through their own practice, create this kind of an incentive even for Switzerland to comply. So we can't think about courts only as dispute settlers, as institutions that clarify the law, as institutions around whose judgments NGOs, activists can mobilize, but we also want to think about them as institutions that create law for the bigger international community and thus shape where the law is going. And we expect, especially in the area of climate change, to see in the future years many more similar judgments being adopted that would clarify not only obligations, but also rights of future generations. So if I can conclude then, what I've tried to do in this lecture is I've tried to show that even though we've got so many cases that are being handled by international and regional courts today, the power of these courts is limited, and ultimately the impact their judgments have depends on states. So does this mean we live in bad times for human rights? I think even if we're noticing many conflicts, we're noticing many violations, when I look ahead, I am hopeful. And I'm hopeful because I think our classrooms have never been so full. Human rights lawyers and courts and tribunals have never been so busy. And the activism experienced amongst the young and within the civil society has never been so loud. And I think all of those three elements give me much hope that the future will and can be brighter, and that once we have new generations who are passionate about human rights in power, that we can encourage states to change their behavior and to champion international law and human rights, both at domestic and international level. Thank you very much.
Thank you very much, Veronika, for this very insightful lecture, very comprehensive indeed. I can see that there are already questions set out. So I will start taking some questions and posing them to our speaker. Please continue to place your questions if you would like so. So it seems that some of the members of the audience are interested in some similar things. So I will ask one question that has two branches because I think they're related. The one is that perhaps it might be misleading to consider the decisions of international courts as binding, given that there is no enforcement mechanism and how perhaps unfortunate or inefficient the non-formal enforcement mechanisms that exist are. And then the second question that is directly connected is whether, I mean, given that international human rights law depends so much on the enforcement by states, is it at all law? Is it at all binding? And is it teethless, in other words? So I will give you these two questions and then continue with the next bando, if that's okay.
Thank you very much for those questions. So in some sense, international law is a very different kind of law from domestic law. Domestic law comes in some sense top down, right? You have parliament, you have the government, and they legislate down. In international law, and that applies to human rights law, states have come together, and these are states that are equal. So we have this, in some sense, fiction or principle in international law that every state is equal to another state. And so states come together and agree to give up some of their sovereignty, to give some of their powers to ensure human rights protection or to trade with other countries or things like that. And they do that through international law. And when they give that up, in some sense, there's no one above to make them do so, because if we had someone above, the giving up of sovereignty would be complete. And so in order to keep that sovereignty, we really insist on international law not having an enforcement mechanism. Does that mean, is it misleading to say that decisions are binding? So in international law, I think we believe very strongly in the expressive power of the law. So saying that what a certain decision says, saying something is unlawful, has a great weight. And even if international law, in many sense, is a tool of discussion, a tool of diplomacy, a tool of persuasion, we still believe there's value in that because it's what we currently have. We don't have an enforcement mechanism. It's what we currently have. But we do distinguish, or we do insist that the decisions are binding and that they create obligations. Compliance is essentially a different thing that we leave aside for states. Now, should the system change, it would require states very much to come together and to agree to a complete surrender of their sovereignty. And that's unlikely to happen. Is international law without teeth? So is it really law? So absolutely, it has rules, it has principles. You know, there's a number of lawyers who are employed to litigate these cases, so it has to be law if you think about it. But also, it is not entirely teethless. So when I gave the percentage of 80% of cases by the European Court of Human Rights being complied with, what it means is that most states comply with most cases most of the time, right? Yes, I spoke about 3 very difficult political cases where states have political geo-interests and therefore may be resisting compliance or maybe delaying compliance. But the reality is that most cases are complied with. And you need to think about international law as a language that states use as a way of discussing issues. And so if a state is consistently violating international law, what that encourages is other states to disregard it as well. And so it doesn't lead anywhere. So states, for the most part, are actually obedient and they comply because they have an interest that other states do the same in relationships with them. So it's a rule book that we use to talk to each other, where states talk to each other. It's a rule book that it drives our states' behavior, how they want to behave towards one another. And there are some cases, very political, sensitive cases, where compliance doesn't come.
Thank you. There are a few very interesting questions. There is a member of the audience that is asking following question. So does the juridification of intensely political issues such as climate change undermine the credibility of courts that stray into contested areas? And perhaps if I can exercise here also my privilege as the chair to ask an additional question. You did mention that we are witnessing the repeated use of veto in the Security Council. And indeed, I mean, the result of that is that many political issues and disputes that could have been resolved within the Security Council, i.e. a political body, instead find themselves before the International Court of Justice, as an example. Do you think that perhaps this shift, what does it do for the court? If we expect that this cannot be resolved politically, and in any case, the decision to comply with the decision of the ICJ is at the end of the day also a political decision of the state that will lose the case. And it's unlikely that it will comply, given that it has been perhaps not very happy with the Security Council discussions. Isn't that also some type of undermining of the court at the same time?
Yeah, so thank you so much for those questions. I think So, courts are used and judges are used to dealing with hard cases. These are obviously both at the constitutional level, at the ECHR level, or the ICJ level. These are going to be difficult questions. So there's no question, that these are going to be easy cases. So that's number one. Number two, though, I think juridification is happening because the political institutions are deadlocked. Does it put the ICJ, the ECHR into a tricky position? Yes, to the extent that they are located in a situation where they're in the news all the time, where they need to be answering questions, giving interviews. This is not what judges generally do. Judges don't think about their role as, public or as publicizing what they do. But I don't think that having these cases necessarily come to the court undermines the authority, the credibility of the court per se. Because what courts will do, and we've seen this in a number of cases, we've seen it with Kosovo, independence, and other situations, courts will identify what is the legal question that they can and have to answer. So is there one? Can we answer it? Do we have the tools? And what is the answer? So once a court, you can plead as a state, you can argue whatever you want in front of a court. But once those judges go into deliberation, they will definitely focus on what their jurisdiction is. And their jurisdiction is to identify and answer a legal question. So even in the climate change cases, even in the genocide cases or any other ones, they will have to go and say, these are the political questions we cannot and should not answer, and these are the legal ones we can. And the legal ones will be, what does genocide mean? What does incitement to mean? What are the facts on the ground? How do they apply to the law? But it will not be about the political. And I think that division of political versus legal is often tricky, it's often hard, but it is essential for the court to really maintain its authority, maintain its legitimacy. The final thing I would say is, what is this doing to the court, bringing these cases, resolving these cases in essentially live as the conflict is ongoing? It is creating incredible amount of workload for an institution that is often understaffed, underpaid, and often states will, for example, in relation to the European Court of Human Rights, states will often withhold money to hold the institution hostage. So these are not easy situations for the court, because it needs to think about how to use its resources and how to do its job in answering the legal question. And it does put pressure on the court. But I don't think per se it undermines credibility of the court. It only does so if the court is if it veers into the political rather than sticking to the legal.
So thank you so much. So another set of questions that I think is quite similar, or rather revolve around a similar kind of theme, is about the reasons for which courts perhaps do not want to comply with binding decisions of international courts, including human rights courts. Is it because, for instance, some are asking, is it because they want to do dodgy things, as the member of the audience is asking, or another one is asking what happens when a state simply does not accept that the court has jurisdiction. So in other words, what is the reasoning behind not compliance with the court's judgments, you think?
So sometimes it will be, and we're seeing this a lot, if a country will not accept, so a country will say, we have not consented to the jurisdiction of this court, and there's a dispute, and the court says, yes, you have, but the country doesn't agree. Those kind of situations often lead to non-compliance. Or if there's something that goes wrong with the composition of the panel and somebody is removed, a country can at a certain point say, we're just not going to comply. We don't recognize this tribunal. And I think these sort of arguments have always existed and they always will be. And it's a way to try and undermine the authority of the institution and try and find a way not to comply with the judgment. And it's sort of like a textbook, a textbook practice of how not to and why not to comply. So you find a reason, that's one of the reasons. The other reasons that states, so one has to do with institution, the other one, as I said, has to do with capacity. But I think some of the most important reasons for not complying with judgments come from domestic politics. And I think we underestimate this. So countries will, and especially leaders, right? When we're thinking about a country, we really need to think about who's in power. And people who are in power will want to speak to or will try and win the next election. And often it is these elections and specific political parties that will resist the international institution, that will resist anything that's foreign, anything that's coming from outside. We've seen this in the last 10 years in a number of contexts, right? We had the Brexit, we had the rule of law crisis in Hungary, Poland, etc. And we've seen leaders really come and challenge the European Court of Human Rights, challenge other institutions, and that's highly problematic. But it is coming from the domestic political really context, the domestic political situation, where part of the narrative that has worked with the electorate is this pushback against either migration or pushback against the foreignness, the international institutions. So I would say that this is also a part of a very recent trend against globalization, which has been enhanced by the new technologies and social media, and therefore it's really gained traction.
And perhaps something for the future. So I think you gave us one aspect of what you think about the future. You sound very hopeful. But I wonder what you think could be done in order to improve and force more compliance rates. You did mention, of course, that the ECHR has an 80% compliance rate, which, I mean, the states comply for 80%, and that's high indeed, but there's always space for improvement for that 20% to become perhaps 10 or even 3 less. So what do you think could be done? And do you think that more generally in the future we can expect more respect for human rights or not?
So these are very hard questions, a lot of guessing. So I would say that what we have found is that, and this is really as part of the project where we're looking at compliance with different judgments, we have found that naming and shaming at international level is increasingly not efficient. And it mainly works with very old democracies, so countries that are established and that care about being named and shamed by NGOs and activists. But for example, so if I give an example of UK seems to be very sensitive to that as a tool and will redress any kind of issues in relation to reputation, similar for Denmark, so kind of old democracies. Whilst when we look at Russia, that is not the case. So the Eastern European countries, at least some of them, are not responding to being singled out or being isolated, and that doesn't lead to a change in behavior. So that's one of the things. The other thing we have noticed in terms of trying to bring enforcement up is really helping with capacity. So states often will not know what is needed to comply with a judgment. They might often be intimidated by the amount of things that need to be put in place. And so at least at this capacity level, for example, creating internal organs that would be responsible for coordinating compliance or coordinating enforcement, that would be responsible for looking at different pieces of legislation and how these interact, or changing legislation, that kind of support has to be provided either within the UN or within the Council of Europe, and that makes compliance better. The third thing is we think the really important role is played by courts here and their secretariat when they are writing the judgments, that they are constantly and consistently asking more of states, so that the level of human rights protection isn't static, even with those countries that voluntarily comply, but that we're pushing what we're hoping for, protections, that we're consistently pushing that higher up. And we find this through different kind of modeling, that if these institutions are not ambitious, if they're too lenient and deferential to states, that the level of human rights protection, international law, goes down. So it pays to be ambitious, it pays to be demanding, that works well. But I think the final point I would say is that I am hopeful because I have never seen so much enthusiasm in my human rights classes. I have never seen so much desire. I've never seen so many students in my classes, but I've never seen so much desire from the young generation to make a difference, to change some of these institutions, to go into their own states and governments and to make a difference, to ensure that people are treated better, and also to bring about systemic change. And that is one of the areas where human rights have not yet been, I would say, have not yet been taken to the point where they can be addressing poverty, addressing inequality, climate change, self-determination. So I think there are still a lot of open areas, but I'm hopeful because of what I see in the younger generation.
Thank you very much, Professor Fikfak, and thank you very much to the audience for your participation and your excellent questions. Well, I have, of course, been unable to take all the questions. There are too many questions for us to be able to address them today. Thank you so much, and allow me to just remind everyone that the next lunch hour lecture is on Tuesday, the 21st of January, 2025, on is reducing investment demand for housing key to solving the housing affordability crisis. Thank you very much, and this is the close of our event.